Good morning, afternoon. Welcome to this month's webinar. You'll be excited to hear that we have four amazing champions in Indian country today who will be sharing their experiences with all of you about different strategies and methods and ways of negotiating with non-tribal entities. Because this is a major part of our job, and sometimes we communicate differently with those on the outside. It's important to have conversations like this today that we could learn from each other, grow, and maybe use some of these strategies in future negotiations with these non-tribal entities. Of course, some principles outlined may be beneficial in other areas of our lives too. But we have four attorneys on today who are going to share these secrets with us. And at the end of this 90 minutes, you're going to know everything there is to know about negotiating with non-tribal entities. Okay, maybe not so much, but close. We have first Pablo Padilla, who's joining us, along with three of his colleagues from different areas, I think all in New Mexico. We have Casey Douma, Aaron Sims, and Justin Solimon. So we have really great representation. I did a lot of Googling on these guys before we invited them out, just so I know what's going on. And I'm like, okay, 2 thumbs up here. So before I hand this over to them, I want to just lay out a few ground rules so that all of you know what's going on. Because attorneys are leading this course, I did apply for Minnesota CLE credits. So those who are in Minnesota, I see a few on our list right there anyway, but also those who may be interested in looking at reciprocity. I don't know how that works completely. I'm not an attorney, but certainly take a look at that if you'd like. The event code is 465158 through the Minnesota CLE. So, we'll share that later with you as well, or if you want to message me directly, I'm happy to share that with you. Furthermore, as I already said, but I'll say it again, this is recorded. Your chats will not be saved. So, feel free to ask, questions as you'd see fit or have conversations and know that that will be respected. But that this recording, the video and audio, will be shared and distributed later this week. So that way we can share it with our relatives and colleagues across Indian country as we move forward with our conversation. And finally, of course, questions and comments should be typed in the text box. Because of the nature of how we're doing today's webinar, we will look at those questions at the end of this session. So even though you have a question for Justin or Casey, you could type it in during their segments and we'll go through those pieces and revisit them. So fear not, we'll get there. So without further ado, I will turn this over first to Pablo to introduce himself maybe more thoroughly and his teammates here, and we'll get this show on the road. Thank you.
Nice. Thank you, Nichlas. Good afternoon to everyone on that side of the country. Good morning to those that are here near New Mexico. My name is Pablo Padilla Jr. I'm from the Pueblo of Zuni. And what I'd like to do is first thank the audience for spending this time with us. I've known these three gentlemen that are also on this panel for years now. This is my 17th year in the practice of law. All of those 17 years representing tribal governments here in New Mexico. So what I'd like to do, if it's okay with the audience, is I'd like to have each of the panelists introduce themselves, where they work, something about themselves. And then once we're done with those introductions, then we'll jump right into the actual meat or the heart of the presentation. So I'll go ahead and let Justin go first. We're going by seniority as far as attorneys. So Justin, could you please introduce yourself?
Hello, everyone. Hope you can hear me. My name is Justin Solimon. I'm from the Pueblo of Laguna, and I also share a little bit of Zuni blood with Mr. Padilla. I am a 2006 graduate of the UNM School of Law. I was sandwiched actually in between Pablo and Casey in school, and I have a lot of fond memories of our time together there. They're about the most thoughtful Indian law practitioners I've ever known, and it was an honor to have gone through law school with them. I've also served on the Indian Law Section Board of the State Bar of New Mexico with Aaron, and Was so impressed by Aaron that I spent most of my time on the board trying to coax him to join my firm, which never worked. But speaking of my firm, I'm with the law firm of Barnhouse, Keegan, Solomon, and West. We're located here in Albuquerque, New Mexico, and we specialize in representing Indian tribes and tribal businesses on all matters affecting tribal sovereignty. My practice, which began about 16 years ago, has been primarily focused on special and general counsel services to Indian tribes, but I've also included a few long stretches where most of my practice was devoted to litigation and generally trial practice, and it's an honor to be here to present. Thank you.
Nice, thanks, Justin. Casey, Douma.
Good afternoon, everybody. My name is Casey Douma. I am from the Pueblo of Laguna, as well as Hopi Tewa from Arizona. And it's a pleasure to be here, coming to you live from Princeton University. Aaron and I are out here conducting a summer policy academy out in Princeton. So it's our first time in 2 years we've been out here. My practice is predominantly with tribal governments, tribal entities. I was a former in-house legal counsel for Laguna Pueblo, my Pueblo, as well as now my current role as owner of Douma Law, which works with tribal governments and tribal entities, as well as tribal colleges. I've sat on Court of Appeals for Chippewa Creek Tribal Court. I'm also the board president of the New Mexico Center of Law and Poverty. I'm doing a lot of good work there in New Mexico. So I'm happy to be here with some really esteemed colleagues with me today. So thank you.
Thank you, Casey. Aaron Sims.
Sure. Goatsi Hopa, Gaita Hopa, Trayashin. Good afternoon or good morning, everyone. My name is Aaron Sims. I'm from the Pueblo of Acoma. Despite my background behind me, I, like Casey, am here at Princeton and we're in separate classrooms. So it's kind of funny. We're taking this presentation from here. I'm a partner at the Chestnut Law offices located in Albuquerque, New Mexico. There, my practice primarily is in Pueblo tribal governmental representation. We're a general counsel for a number of Pueblos and tribes, and I have the unique opportunity of being able to work on behalf of my own community, the Pueblo of Acoma. So that's who I am, but I'm really pleased to be invited to speak. Thank you.
Awesome. Thank you, Aaron. What I like to do now is, I think how I like, because of the number of individuals who are interested and are taking part in this seminar, I like to leave a lot of room for discussion. I think that's an important aspect of this. So Nichlas, you'll be facilitating that when it comes up, as far as questions that you have, issues that you would like us to address generally. But I'd like to go ahead and begin. I'm going to start by telling a real short story. This is very recent, and there's some lessons to be learned from it. I have a client that has tribal trust land right in the middle of a city. So this is right in the middle of Santa Fe. The client's the Santa Fe Indian School. And about a year ago, the client embarked on a new front entrance project. So if you can picture tribal trust land right in the middle of the city, right next to one of the major roads that goes through the town. And one of the issues that came up in developing that new front entrance project was a new fire hydrant. And this new fire hydrant was to be placed using city water in the event that that fire hydrant is needed for whatever water services that the client needs. The city of Santa Fe has a form that they utilize with which to install these water hydrants and allow their workers to have access to it. One thing that happened in this project was the city of Santa Fe required a lease or an easement with which to enter into the tribal trust lands in order to, one, install that hydrant, and then two, to repair it in the future and to maintain it. And interestingly enough, that whole project was stalled for about a year. And the reason why that project was stalled for about a year was because the city of Santa Fe needed something, and the client in that case could not give that to them. And what do I mean by that? What I mean by that is in order to get an easement, on tribal trust land. A lot of you on this call may know that you have to go through the Bureau of Indian Affairs. There's a consent of easement. There's a whole set of regulations that have to be complied with, compounded by the fact that this land was held in trust, not just for one tribe, but for 19 tribes. And so it wasn't until month 8 or month 9 till legal counsel was asked to help fix the situation, find out what's wrong, try and move things forward. And what I realized, and this is the point that I'm trying to make with this story, I realized that the city was asking for something. And even though the Pueblos couldn't give the city what it wanted, which is an actual easement or right of way, leasehold interest, I looked at, and I did something very simple. What I did is I went to the Black's Law Dictionary and I said, well, what else can the Pueblos give to the city to allow them to get what they need and to not have this project stalled for much longer? And I came up with looking up the term license, very similar to a driver's license. It's a very special type of permission that can be given. So what I did is I called up the city attorney. He and I looked it up. He and I decided, yes, that's what the city needed. We drafted a provision in there. And sure enough, within a week, that project was installed. And that's a very recent project. I have a lot more stories to tell, but from that story and from that situation, the advice that I give people on this call here is, one, to engage legal counsel at the very beginning. I think one of the problems that exists in Indian country is when land managers, tribal leaders, they have to have the onus of deciding when to engage legal counsel. And it's been my experience, and this is 17 years on this, that to engage legal counsel at the very beginning saves a lot of money, saves a lot of time, and saves a lot of headaches. The second point to that story is, and this is something I learned at Harvard undergrad, and that is, don't let the good be the enemy of the perfect. And what do I mean by that? The perfect situation for the city in that situation would be an easement. They get it from landowners, they're used to it, they know the term. But in this situation, because of the amount of time it would take for 19 tribal councils to issue easement and a lease for that hydrant, we set up for something that was good, and that was a license. And it passed muster for the city. The school was able to give that without having to go to the tribal councils for an actual easement, and things moved swiftly because of that. So I'll end there, and I'm going to give Justin some opportunity now to talk. Thank you.
Thank you, Pablo. I have about an 8-year-long story to tell, and hopefully about 10 minutes. I'm going to do my best. I'm not a good gauge of time. So if anybody is annoyed by my story, I'm taking up too much time, just wave into the camera or cut me off, mute me somehow. But so I'm going to tell a story about a very lengthy and complicated right-of-way negotiation that covered about 8 years of my life, in which my client, which was a tribe, and I encountered just about every possible complication you can encounter to resolve a utility trespass and right-of-way negotiation. And so as I relate this story, I'll try to highlight and revisit some of the tactics that we used to get through those complications that resulted in the tribe finally being able to close its books on this long-standing but ultimately successful, I'll call it an ordeal, rather than just a deal. So in about 2013, when I was only with this firm, my current firm, for a few days, my former partner, who has since passed, Carl Johnson, asked me to take over a project. And he didn't give me much detail, but being new to the firm and somewhat eager, I agreed to take it. And so at that time, the firm was representing a small tribe regarding a trespass issue involving a single electric transmission line on both tribal lands and a small portion of allotted land. And that utility had about a 25-acre footprint. The line had been in trespass since approximately 2006. So it was a holdover trespass. And that essentially means that it previously had a right-of-way for the tribal and allotted lands, but the right-of-way had expired without any negotiation, renewal. There was efforts, but those were unsuccessful. And as was common at that time, sort of the early 2000s or late 1990s, the right-of-way that had expired was approved by the federal government decades ago under during a time in which there was a policy that where the tribes didn't have any real say in the negotiation or approval process for encumbrances on tribal lands. So the utility was essentially living rent-free on tribal and allotted lands, and something had to be done. The first task I had was to attend a meeting with the tribal client and the utility company. The utility company was a small rural water district that had the authority and responsibility to provide electrical power to the region on which the reservation sat. The meeting was to present our sort of opening offer, our valuation of the trespass, historical trespass fees, and the right-of-way value is to present that to the utility companies. That's sort of the opening session of a negotiation. The meeting did not go well. It was really the only time as a lawyer which I really got proof of a deep-seated disregard and disrespect for tribes from a utility company. And I'd been in many other negotiations, including other right-of-way negotiations, and dealt with dismissive attitudes, dealt with a lack of understanding of tribal sovereignty, but this one was particularly different. For the next several years, we really struggled to get meaningful responses from the utility to that opening offer. There were attempts by the utility company to try to separate the trespass from the right-of-way negotiations. In other words, we won't negotiate the right-of-way until you settle this trespass claim. There were also attempts to stall or otherwise get the tribe to negotiate against its own opening offers. There were also threats, which I'm sure many of you encountered, where the utility says, fine, we're going to take our line and move it, which, as you may know, is really never economically viable to a utility company. But there were a lot during that several year period. There were a lot of the times in which we were close. We had a settlement term sheet. There were signature lines on it, but at the last minute, the utility board would change directions very suddenly, and we would lose or reverse the momentum that we had. And so we were at an impasse. You know, we knew we were at an impasse shortly into those negotiations. You know, and along the way, we sought BIA's assistance, and that didn't break the logjam. We nearly filed suit to eject the utility, and the tribe certainly, you know, thought of or considered taking matters into their own hands by forcibly removing the transmission lines. And so rather than take any of those actions, which would have delayed the process or potentially created some longstanding complications and adversity between the tribe, the allottees, and the utility, we decided to engage in sovereignty building activities to essentially enhance tribal laws on dealing with trespasses, and to prescribe a process by which a trespasser, in this case a utility, could or would have to follow in order to start and complete negotiations of a trespass at any future right-of-way easement or lease, should they wish to remain on tribal lands. I'll talk about the code that the tribe adopted a little later, and it involves some of the tactics employed by Pablo that he just referenced. But essentially, it's to create a carrot and a stick approach to prod the utility to engage in meaningful negotiations, to avoid stiff, penalties or enforcement actions with certain incentives that I'll discuss. But it's also to create a deadline under tribal law with enforcement actions that can happen during and after that deadline, really to make sure that you have a track that the utility must follow to successfully resolve a trespass and engage in a new right-of-way. So the tribe, after passing that new tribal law, began enforcement action under that ordinance or that code against the utility. And that ended up proving that this carrot and stick approach was going to work, because the utility, at first they were skeptical, but they did respond. And to avoid, the heavy penalties that were assessed under this code, there were meaningful discussions, and the tribe and the utility got very close to settling the trespass and agreeing on terms of a new utility right-of-way. However, again, this is another complication. During the final stages of drawing up the settlement terms, the utility kept inserting what I would call like global settlement language into this agreement. The language read very overly broad, and sort of suggested that something else was going on. This was not limited to resolving one transmission line. And so during that process, we engaged in an investigation, and it learned that the utility had other transmission and other distribution lines that were in trespass on both tribal and allotted lands. In fact, it was 6 additional lines. One of those lines dated back to the 1960s. So not only did we discover additional lands, but these lands were a lot more complicated because they involved substantially a lot more allotments, a lot less tribal land. So the tribe is a little bit, as we'll discuss, a little less removed from being able to finally settle those. In addition, we had substantial history of trespass. We're not dealing with 10 or 15 years. We're now dealing with decades and decades of historical trespass. So how do we value that? How do we resolve that in compliance with tribal law and federal regulations? So we started that, but because of the ordinance that the tribe had adopted, we were on a fast track. And so we were able to resolve this now more complicated settlement about 5 years after I was first handed the file in 2013. And as a side story, I was taking the calls to negotiate the settlement with the utility, to get approval from the tribal council, all while I was in a witness prep room at the federal courthouse here in Albuquerque. That was during the final stages of a lengthy 20+ day trial that started in October and ended in December on a different client, on an entirely different Indian land issue. So it was a weird balance for me as an attorney to go from courtroom taking breaks to negotiate this thing that I had been dealing with forever. And at the time I was thinking, really, like, I've spent 5 years in my office comfortably sitting in front of a computer, and now I've got to settle this in breaks while in trial. And so, we got it done, and it was effectively settled. We had an agreement with substantial terms. The money went into escrow, but now actually comes the most complication that we had in this negotiation. So, which is the allottees. To resolve the trespass and to negotiate a right-of-way, the tribe and myself, we cannot legally bind the allottees. Under federal regulations, the majority of the allotment interest holders have to consent, and separately from the tribe. So the tribe could have effectively washed its hand of the allotted lands and not dealt with that, which probably wouldn't have been successful. Instead, the tribe decided, well, these are fundamentally, primarily our members. We need to include them. We need to do the outreach. We need to get them to consent before this is actually resolved. And during the negotiations, because we had great consultants, we had a really strong valuation, we had good Indian land value comparables. The negotiation value that we reached was anywhere between 3 times to about 18 times the fair market value of the lands per acre that the BIA had assessed along the way. So we had this incentive for these allottees to consent, and we assumed it would be easy, right? But we were wrong. We had hundreds of allottees to contact. Some were members of the tribe, some were not. Some had been at the meetings with legal counsel or tribal counsel, and some had no idea that there was a utility. Some really didn't have any connection to their allotments. As with allotments, many of the people that we were trying to obtain these consents from had super fractionated interest. So they would only be receiving very small compensation for sometimes longstanding trespass because they had such a small percentage of interest. We also had a few consent holders that were critical, that were incarcerated or homeless, or their whereabouts were unknown. So we had a lot of public meetings. We had to send out a lot of correspondence and follow-up correspondence as a result of these meetings. We had to convince people to sign documents that really only guaranteed that they get a few dollars, in some cases hundreds of thousands of dollars, but it was very tough. But we finished that process about 6 months after essentially settling the issue with the utility, and the tribe decided to take the lead on that process because we felt we were in the best position, that more so than the utility, to engage in that outreach. Adding another complication, which was actually a very substantial complication to this already lengthy process, I had a dispute with BIA regarding the interpretation of certain federal regulations on the consent required for allotments where there was a life estate. I don't even want to get into that. I'm still recovering from it. It added an additional 6 months to the process, but in the end, BIA agreed with our interpretation, and we had the required allottee consent threshold. We had the majority of the interest holders that signed the documents to get this settlement of the trespass resolved and to get a new right-of-way in place. And so the last checks were cut within just really the last few months. And I still haven't accepted that it's over, even though it is over, because I've sort of developed trust issues over this process, because every step of the way, the issue got bigger and more complicated, and the tribe and myself grew more frustrated and more willing to just want to walk away from this process because of how long it took. Based on my experiences, I kind of want to highlight some of the tactics that we used to get through the complications we faced in this story that I've just provided. None of these are my creation. These are tactics or variations of tactics that I think have been used for many years, or at least several years, but I found them particularly effective in dealing with this issue. The first sort of tactic or knowledge that I've gained is, the federal government has more and more acknowledged the authority of tribes to control the negotiations of leases, easements, rights of way on tribal lands. This is not new, but it does create two issues. The first is the BIA or federal government's not going to step in and do this for you. Tribes have to take that authority, they have to use that. So if you do not have a tribal trespass code or some other mechanism in which you can take enforcement action under a real prescribed process under your laws, there's really no default federal laws or regulations that the utility is going to agree to use to complete negotiations. And in instances of holdover trespasses where they're already living rent-free on tribal lands until they have to pay the trespass fee, it benefits them when you don't have a process with timelines and deadlines to use to complete negotiations. So you want to get, either through a trespass code or some other mechanism, the ability to have some teeth, to have something that you can present either to a federal court, tribal court, arbitrator, whoever, of value, how the tribe values its land. The second one is a little sort of cuter, but you want to get the utility used to cutting checks to the tribe. That's something that it sounds silly, but if you make them start making payments towards something like a license or something that might be either temporary or fees to apply for a right-of-way permit or right-of-way application fee, those are ways in which the utility gets the tribe's routing number and wiring instructions, gets used to signing checks, because sometimes that's the biggest thing. They're worried about that big check at the end. And if you get them used to participating in a process by which they're paying the tribe, I think it goes a long way to having them cut the much larger check at the end of the day. So make them pay a land use application fee or a right-of-way fee. If it's a new right-of-way or if it's a renewal, create a process or a form that prescribes what the fee is. If you want to renew this right-of-way, or you want to have a new right-of-way installed on tribal property, here's the application, here's the fee. The fee really, I don't really have a recommendation on it, but it should be a fee that accurately and reasonably reflects the expense that the tribe is going to have to negotiate settlement of a trespass or renewal of a right-of-way. So you want to measure it based on the complexity of it to offset the attorney's fees, consultant fees, tribal staff fees that are involved. And you want to make it non-refundable. You want to make it so that way it gets them in. And if they drag their feet, you cancel the application. If they want to renegotiate and you've canceled it because they've exercised no good faith or they haven't complied with the conditions of the application, cancel it and tell them they've got to reapply. And it's up to you at that point If there are additional fees that come through the utility failing to negotiate, you may want to prescribe an additional fee. And similarly, if you're dealing with a holdover trespass, so that may be rare or that may be common where you're from, but that's an expired easement or right of way that for whatever reason, before it expired, it wasn't renegotiated. And so you have, again, a condition where somebody is occupying tribal lands rent-free. You want to create or add to your laws or your trespass code in this instance, a process for enforcement action against trespasses that are held over. You want to create penalties. You want to create the mechanism that you would have to follow to collect on those penalties. That's the stick. But you also want to create an incentive, a carrot, to incentivize those meaningful negotiations for the utility company. And you can do this by creating a process under which the trespasser will pay a temporary land use license fee. So you're creating something that's not a full lease. It's just a limited permission. So for this 3-month period or this 6-month period, we're going to agree to stay or hold off on an enforcement action. Those penalties that we are assessing that are accruing by the day or by the month, we're not going to charge those during this license fee. As long as you pay a license fee, which could be based on codified values per acre of tribal land. As long as you pay those, as long as you have a license, as long as you are moving towards negotiations for this limited period of time prescribed by tribal law, then we're not going to create those adverse actions. We're not going to sue you. We're not going to try to take any other enforcement action in an adversarial nature. We are going to agree to stay that, to sit across from you to negotiate this right of way. And one thing you can do is, those license fees that they're paying, you can make them refundable or creditable against any final settlement. So if they've been paying, if they've got a 25-acre encumbrance or trespass, and let's just say you've made them pay, I don't know, $10,000 a month or $50,000 a month, the amount that they pay each month is creditable to be offset against the final full settlement. So they're now cutting small checks, but they may get them back. It's sort of like a down payment against their final settlement of a trespass or a new right of way. And so what that does is it removes sort of the adversarial nature of it temporarily. It gives them a limited period in which to actually and finally complete these negotiations. And that's the carrot that hopefully encourages everybody to get to that finish line. And sort of the last point is you just cannot give up. No one, regardless of how strong of a BIA, local BIA you have, regardless of the judges that might, you might feel benefit, Indian tribes in this instance, they're not going to do anything about it for you. You have to steer the negotiations from start to finish. And in many instances, it can be a lot of work. It can look insurmountable, or you can encounter complications. But if you create a process, it should work. It will work. So that's all I had for my story.
Thank you, Justin. That was very thorough and very enlightening. Casey Douma, do you want to go up next?
Great. Thank you, Pablo, and thank you, Justin. Thank you for the good stories that you've all been sharing. I think one of the important lessons, just definitely in my practice, and as well as being a in-house legal counsel for a tribe, is seeing things from the front end before they can escalate. And what Justin covers is very important, having the groundwork done as far as making sure that you have the codes in place, the regulations in place, any fines and fees identified, so that if you run into these situations, that you're covered on that end, that you're not having to play catch up or coming from a stance where that's your leverage is gone, basically, if you don't have anything in place on a tribal level. So developing those codes, developing those regulations internally, just as a matter of practice, and it may not be in anticipation for a specific project, but just in general, going through that checklist of, do we have sufficient laws on the books to make sure that we can be ready for these situations? Oftentimes within tribes, we don't jumpstart the process of developing these codes until they're necessary, or we're behind, where an incident has already arisen. And so having as part of practice a process in which you are able to review current laws, be able to utilize subject matter experts within your own tribes to say, are the laws that we have sufficient? Do we need additional language? What wording that needs to be amended? And what regulations need to be developed to accompany those? Those are things that are very important as you start to plan out what will be beneficial should you ever get in a situation where you are negotiating with off-reservation entities. And so certainly having that infrastructure down is important, because that's one thing that we see from working with tribes, is that having that legislative process is very important. Having a developed process internally to help the tribe develop those codes are very fundamental to protecting sovereignty, because it prepares you for situations such as these, as were highlighted in the examples. So it's a type of maintenance. I think of it as a vehicle. You get the oil change, you get a tune up every now and then. Same thing with tribal government. You got to keep the laws fresh. You got to keep them amended and reflecting what the needs are of the current environment. And so that's one thing that's important, I think, in really looking internally to prepare for negotiations in the future. And some of the things that are important, and I put this in the context only because it's something that has recently, for me in my career, was at the forefront of my whole last year, and it was negotiating with off-reservation entities, the very subject. But in the context of a larger set of real estate, which was the entire state of New Mexico, when it came to the redistricting of the entire state, the voting districts, and having 20 plus tribes engaged in working together. One, that's a task within itself of developing a consensus amongst 20 plus tribes within a state around anything is one of those difficult tasks. So being able to build alliances with your neighbors is very important to really looking at issues impacting the land of our peoples. And so getting involved, engaged with leadership, tribal leadership is very important to build those alliances, because as we begin to look into those negotiations that took place, we're able to fall upon those relationships and call upon those relationships when we needed to actively engage. And in the political climate, and some of you may have issues that are ongoing and running, that a legal solution may be far away, but a political solution might be the more beneficial approach for the moment. And so in those situations where you have kind of two pathways to get to the same destination, the legal route as well as the political route, building those alliances are very important, because that is where when push comes to shove, depending on those alliances are going to be key and fundamental to really leveraging the tribe's interests. And so that's one thing that we saw within the state of New Mexico with this last redistricting process. So if you think about being able to carve up the state into voting districts, and that requires a lot of coordination amongst many entities. And so part of the strategy of doing the groundwork, so when you think about in the context of what you all may be seeing and experiencing on a daily basis, is doing the groundwork, being prepared. Just as Justin mentioned, nobody's going to do it for you. You have to be prepared to be able to have the infrastructure in place, the legal infrastructure in place. And so one of the things that was important for us during this process was the ability to develop our own subject matter experts, to have that information ready to go. So that way we weren't depending on others to develop that information for us. We were the ones being able to develop, whether it was our own mapping systems, whether it was our own identification of important areas, such as sacred sites that we wanted to be included within a certain district. So all of these factors, I mean, we left nothing to be interpreted by others that wasn't interpreted by ourselves first. And so having the ability then to control the use of your own data is important. And so that's key in the negotiations, because if someone else is determining what that data is, what those measuring tools are, then you may be surrendering leverage in negotiations. So it's always best to have control of developing, as accurate as possible, the information coming from the tribe, from its reservation. And if that's not up to par, if there's resources needed, if there's training needed, it's in the best interest of the tribe to make sure and ensure that the tribe is capable of providing that to its departments, to its programs, to be able to engage in these situations. So whether it's in my situation more recently with voting rights, or whether it's negotiating water rights or any type of issue, having access to your own experts and being able to really develop that expertise internally is fundamental. And so those are things that kind of as skills of negotiation are important. Leveraging, finding what is the solution, and having that backup plan. Certainly when we engage with multi-tribal negotiations, that in itself requires a huge understanding of the layers of decision-making that exist within our tribal nations, within our Pueblo communities, especially when it comes to land. There is not just negotiating with the top leadership, there are also the local leadership that comes into play, which has a huge amount of influence over the land and how it's distributed and whether or not an easement, right of way, or lease can occur. So being able to coordinate amongst multi-layers of decision-making is important, because when you're negotiating with off-reservation entities, it becomes very important to be on the same page. So coordinating amongst the various departments to align yourself so that leadership is aware of what's occurring with the different departments or segments in different entities that work for the tribe. Those are very fundamental to kind of coordinating and negotiating strategy. And so those factors that come into play are, our preparation. So a lot of the work that we do as attorneys, are focused on different levels of the spectrum. One, after something has already occurred, where we're totally engaged in kind of fight mode, and then a lot of the heavy lifting, in my opinion, should be done at the front end to ensure that we have a lot of those things in place before we run into a lot of problems. Some things you just can't catch, some things you can't catch, they arise, issues arise that are very unique, but to the best extent as possible as tribes, we have to be in control of our own house, basically, it's kind of taking a lesson from my grandma, like keep your house clean, and keep things in order, before we kind of step out. And so that is something that's very important for tribes to do its own inventory of their laws, do an own inventory of its policies, to ensure that we have the necessary infrastructure in place so that when we engage in these types of major projects, such as bringing a wastewater line through the reservation, that we have things in place necessary. We have the codes in place to do what we need to do, whether it's providing the necessary approvals or taxation authority, where we have everything spelled out. All of those things are in place. So that's a bit of what I wanted to share, is highlighting that part from a negotiating standpoint, and also coming from my perspective, working as in-house legal counsel, is the amount of preparation we have to do internally to ensure that we have successful negotiations. We have to make sure we do that inventory within our own tribal laws, codes, and policies. Thank you.
Nice, thank you, Casey. And then to round off the presentation, Aaron Sims, you're up next.
Great, thank you, Pablo. And thanks, Casey and Justin, for leading off. You shared a lot of good tips, which I think are universal in our support for those kinds of approaches to negotiating with entities outside of our tribal lands. What I want to talk about is some of what my practice has covered involves a lot of cultural resource protection. Often when there are projects, large projects that become federal undertakings or require some sort of approval by the feds, they trigger a bunch of different processes, one being the National Environmental Policy Act as one arm, another being the National Historical Preservation Act as another arm. And I want to focus here on part of that under the NHPA, which is the Section 106 consultation process. I have the experience of working with one of our clients on a project related to a trans state pipeline, where one of the selected alternatives for that pipeline, which is huge, it was something like a 200 mile proposed pipeline. The preferred alternative was going to go through a portion of our client's reservation. Using that to our advantage, and kind of what Justin was saying, where the feds really allow the tribe to negotiate with that entity on how it was to engage in what it needed to do as part of analyzing, as part of the Section 106 process, the cultural resource inventories necessary for that. We really use that to our advantage to try to insist on some concessions from that entity. And part of that need to do that came from two sources. One, in experiences outside of our reservation. We've had some very troubling experiences where, and kind of moving back to a kind of a larger conceptual level of, at least in those processes in the Section 106 process, the kind of disconnect between the understanding of what is important resources to our tribal communities, where in a lot of times under those processes, there's a heavy emphasis and look on the tangible things, archaeological resources, that are things that might be eligible historic properties under that act. But as many of us know, as members of our communities or practitioners and tribal communities, what's important as a cultural resource might not always be readily identifiable to outsiders from our own community. And so in some other instances, we've had some very bad experiences with that, and kind of took this then as an opportunity to try to create a new model to approaching these kinds of consultations. The major thing that occurred when we were working with the entity, and we stayed in close contact with the local federal offices. In this case, it was the local BLM office, because the pipeline was for the most part situated on BLM land, was coming to an agreement on how the cultural resource managers for the proposed company were going to conduct the necessary Section 106 process on that part of the tribe's land that the right-of-way would cross. Some numbers for you, just to give you some context of that problem that we described, or that I described, about the difference between kind of cultural resource management approaches and kind of this archaeological versus cultural resource issue. Already before the pipeline ever got to the reservation boundary, there had already been survey, kind of what they call this Class 3 survey of approximately 100 miles of the pipeline's corridor. Identify historic properties by the company CRM team was something like around 50 or so historic properties identified. In what was to be eventually the outcome of our study and work on this kind of 12-mile transect that crossed the reservation boundary, working with the community and the tribe, there was probably 3 times that of identified cultural resources, historic properties, just in this little 12-mile transect, compared to this 100-mile area that their cultural resource teams had already done and identified far less than that. So how do we get there to get to this identification phase? The major thing that we had done in approaching negotiations with this company was a few things. Just like Casey and Justin had already described, we had a lot of the work done. We'd had some of our homework already done here, where the tribe had already established appropriate tax codes, appropriate realty codes to be able to implement the appropriate licenses and permits necessary for this kind of a project, and also to receive some revenue on the back end by being able to implement taxation for appropriate business licenses and operations of the cultural resource management teams on the reservation. The other major thing that we did develop, and this was sort of kind of building the plane as we were flying there in that other kind of example, was the development with the tribe and their historic preservation office of what we've called kind of a rapid ethnographic assessment team. And that was huge to change the game here. And what we did to convince the company really and get the blessing of the federal agency to this approach was some of the things that Casey just mentioned. Understanding and working to have the company understand that money-wise, they were far better served to work with us at the get-go, work with our historic preservation office to allow us to put into the field with their own cultural resource management teams, members of our own community as part of a rapid ethnographic assessment team, to be in the field with them. And also many times to take the lead before them to clear some of these areas where this proposed right-of-way and pipeline was to go. And it worked great. We showed them that, what could the results be if they didn't do this? The possibility of expending huge amounts of funds for having to redo this work, redo these surveys, extended negotiations with us, the potential for litigation, kind of this parade of horribles, when it's far better to, work with us from the get-go. And so it worked really well, and we were able to work with that company to not only pay for what they needed to in the appropriate permits and licenses and taxation, but also to work with the tribe as part of the negotiations to pay for the tribe's reasonable costs. So in this case, it also included the payment for those members from the community who made up these rapid ethnographic assessment teams, and not just paying them kind of a stipend or something to kind of as a token payment, really negotiating with them that, the experience and knowledge that they have is really equivalent to the expertise of the cultural resource management individuals that they have. And so, they paid at costs, at a reasonable cost of the tribe's expenses and engaging in that. But it became really a successful model, so much so that out of that entire 12-mile transect and all of those historic properties and cultural resources that were identified, the company was able to route the proposed right-of-way in such a way where it avoided all but one historic property, and it just kind of nicked the corner of a historic property. And with having our teams there as part of the process, we were able to also work with the company and also with the approval of the federal agency to come up with appropriate mitigation measures that were appropriate for the community, not kind of the other way around where mitigation measures are proposed and they're presented to the community, and then we say, what the heck? And then we kind of go in this, circle back and forth. So that was really a big success for us. And we've used that model now in other negotiations off of the reservation, off of the tribe's reservation. And we've kept kind of the local federal offices informed of our successes here. We've done presentations on this model with that company about the successes of this kind of consultation and approach to working with tribes and these kind of issues. So that's a little bit of what we've done. It seems kind of like a no-brainer thing, like just, work with us, collaborate with us. But it took us kind of leveraging and seizing an opportunity here, but it wouldn't have also come with some of the advice of the things that Casey and Justin and Pablo have laid out of really the framework that, tribes really need to start thinking of being having laid first. So when these issues do arise, you're not trying to build too much of the plane while you're flying it. So I'll turn it back over to you, Pablo.
Nice. Thank you, Aaron. Excellent. I appreciate the stories you all told. I think at this point, Nichlas, do you want to pick some questions and maybe read them out loud, and then one of us will answer them? I think that's a good way to proceed.
Yeah, first of all, I just want to say, I really appreciate the four of you going through these really complex issues in a short amount of time. You could almost do an entire presentation on each of your issues yourself. So, I know that, I think on behalf of our participants, and certainly the foundation and the National Tribal Land Association, I thank you for sharing this with us, because it's really beneficial. And in fact, one of the questions that we have right now that has come in is actually directed to potentially all four of you. And in reference to something that Casey mentioned during his piece, he said there are instances where, the unforeseen does come up, right? Like there are just sometimes opportunities or spaces where something happens and you weren't ready for it. And so we're wondering, whether, you get some feedback from, 2 to 4 of you on an unforeseen occurrence that maybe happened in one of your stories, and how did you navigate that, since it was a little more unpredictable? Are there strategies that helped you to get through that issue, or what kind of advice you might have for our participants in that way?
I'll start very briefly. One of the advices I give, or pieces of advice that I give to my clients when I'm starting out a matter, is being very articulate as to who the client is. That's really important, because we all either represent tribal entities or tribal governments. My forte is in tribal governments, and there's certain levels of authority that the tribal council has, that the governor has, department heads, etc. And I like to be very clear at the very beginning as to who the client is in that legal matter, so that when an issue arises, and Justin's entirely right, so Casey and Aaron, that these things come up, that you know who to go to in order to resolve the issue. If you don't have that conversation with the client at the beginning, then it makes it exceedingly difficult to deal with these things that come up if you don't know who exactly to go for. Who has delegated authority to make this decision? Do I have to go to council on this? Is this something that the governor can resolve? And so without, I was thinking about an example of a situation where this has come up, but in all those situations that have come up for me, it's been really important to know who the client is in that situation, so that those issues can get resolved. Others?
I can just maybe sort of relay race that a little bit, and maybe hopefully not just repeat what you said, Pablo, but it's really important to know the way the tribe functions, in addition to just who has the authority, who's going to go to these negotiations. Are you going to form a committee authorized by the tribal council, or in cases of tribes where they have a limited tribal council, maybe they have a general council of all members above them. Make sure you have all of that authority. Make sure you sort of can come up with the brackets of what authority that negotiation team may have in meetings and in correspondence, and when they don't have that authority to engage. It's also, and I've done this, I did this in the story I relayed, and I've done this throughout my practice. I have maybe drafted something or suggested something to the tribe in the form of a resolution or an ordinance or tribal code that maybe didn't fully reflect the way the tribe wanted to do things or has done things. You know, you have to really know what works for them, get their involvement. Don't just present a model code that you think is going to work and that you understand, and be prepared to, you know, maybe make some concessions on what you think as either an attorney or a representative of the tribe, to make sure that what you're putting in place is workable. It's something that they can use in other circumstances, and doesn't require necessarily a lawyer to interpret and remind them how it was set up either by them or hopefully through meaningful discussions and considerations with the tribal council.
I think kind of highlighting what Justin had said, and in really creating that paper trail is really good in negotiations. Whether if it's a council resolution designating a certain decision, you can utilize that as leverage when push comes to shove, because the tribe's decision-making process in itself can be a leveraging tool. If things are moving fast, knowing that you have to go back to tribal council or through the various layers of decision-making may be enough, because of the essence of the time, may be enough to create some sort of room for further kind of surrendering on the other side, because not wanting to stall the process a lot further. So being able to create that record of decision making at the tribal level by council resolution, or if you're working with multi tribes on an issue, being able to get joint resolutions in place, that's been very helpful for me in negotiating a lot with non-tribal entities. Is that when you have that affirmation of a tribe's decision, then it gives you a little bit more leverage going into those negotiations, and knowing that that decision that was made by the resolution was one that was thought out by the council, deliberated upon, and then decided upon. So it gives you the advantage of not having to kind of make decisions on the fly, and puts you in a better position to negotiate. Thank you.
Aaron?
Yeah, one thing, I would offer is the concept of just kind of early and often on both sides of this coin. The first side of the coin being in working with our clients, we often say and advise them, please just give us a 10-minute phone call if there's an issue that you think's coming up or a project coming up. Sometimes that 10-minute, 15-minute phone call just to screen issues can save the tribe on the back end, tons of work because an issue blew up in their face. And so I know sometimes there's a hesitancy to engage legal counsel early in a project and kind of wait till, it's at a stage where you're just kind of reviewing the final documents at that part. But really, it's beneficial to engage legal counsel early, just to be able to screen some of these issues and sort them out so they don't become a problem on the back end. On the flip side of this, it's also for entities engaging with tribes, the idea of early and often is equally applies for corporate executives who are concerned about how a project can get done, without really engaging with tribes in early and often on these kinds of examples really can lead to tremendous disruptions. And tribes have been very successful in defeating and stalling and making it completely economically unviable for many of these projects to happen. And a lot of that comes because there's been a lack of early and often engagement with tribes on these issues, just to collaborate more so, to allow the opportunity for collaboration more so than adversarial negotiation. So early and often as an approach to everything is good.
Thank you. Something else that comes to mind has been, these acts of actual practical sovereignty in your different examples, like that, whether it's, developing codes and ordinances, assessing fees, having an active participation in these conversations, even when the entity doesn't really want us to be present there. They don't see us as legitimate, yet these acts of sovereignty, while maybe not so sexy as some of the other things, are vital to, how our governments run, how our nations are operating. But sometimes that is a problem. In some of your cases, you brought up government agencies. The BIA is not, is a non-tribal entity, but it's full of our relatives. And then you have the BLM, which has some of our relatives there, but it's mostly not. It's focused on something else, and so we're wondering whether you have any advice and how to negotiate, how to deal with, those types of entities. When we have an entity that is supposed to promote the general welfare, self-determination of tribal nations, the BIA, yet it's full of our relatives as well. And some of those challenges might occur because of those relationships, but alternatively, it's important for us to be really, really engaged in this process. This is our process in our nations. Conversely, we have other organizations or other associations with the government that are different, and their goals are vastly different than those of the BIA. And so do you have any advice for participants and how to continue to develop a professional relationship with even the BIA as we promote our own decision-making and sovereignty?
I'll be brief on mine. My advice to clients is to establish a relationship with the individuals at the BIA that are actually doing the work needed to happen. I've developed that in my career, and it's really helped the client with regard to something. One example is a feeder trust application. One of the things is an alter survey that's required. My relationship with BIA is such that we could just send that survey in draft form for them to look at, point out errors, and then send it back to the tribe informally before it goes into the feeder trust application. That's a really small example, but I think developing those relationships with what I would consider an ever-changing personnel list at the BIA, those of you that have worked with the BIA know what I'm talking about, is a challenge. A lot of times superintendents move here and there. A lot of times people retire. COVID has really put a dent in the workforce at BIA, but that's an entity that, for better or for worse, the tribes have to work with. And so developing those key relationships and maintaining those relationships has been something that I've set as my goal when representing clients, so that matters, big matters that they're working cannot be stalled by the Bureau at that level.
Just briefly, I've found that I've typically gotten better results if the tribal leadership is communicating with BIA on issues that I may otherwise have a strong opinion on, or may have attempted to get either an agreement with BIA on a process, or a disagreement in many cases. And maybe it's just me, and maybe it's just how I come across, or whatever. But a lot of times, if you, as a lawyer or as somebody that may not be a tribal chair or governor or on council, but you have a good understanding of the issues, is preparing, those the tribal leadership to meet with BIA, preparing them, giving them talking points on the issues so that they can directly present it to their BIA contacts, because it typically yields better results than when I get involved or a lawyer gets involved and then their lawyer gets involved. A lot of times you get a better result and the result that you want by making sure that those are coming directly from the tribe.
Yes, I agree with that sentiment, and utilizing the leverage of the tribal decision-making process. There are times where it needs to be leadership involved, directly engaged. It's in engaging when the level of involvement from tribal leadership is important. You don't want to put too much on their plate that might be a little bit more difficult load to carry at times, given their workload, but really gauging where you need to be speaking directly with folks at BIA, as well as when does leadership need to be speaking to them. That's a really artful skill to have in weighing how you utilize the leadership of the tribe to really make an impact on smoothing the process out a little bit more, and sometimes withholding and letting the kind of like the worker bees do what they need to do. Thank you.
one tool that we've worked with our clients to get, and it's pretty simple, is trying to get established with local federal offices, whether the BIA or the BLM, and really working at that regional level, is to establish like quarterly meetings between the tribe and the local regional office, just to have the opportunity for kind of frank dialogue between tribal leadership, or they can bring along whoever they need to, program directors or what have you, but really just the opportunity to share what's going on. What are the areas of concern? What are the projects of concern? What do we foresee and later on happening in the year? And it's really worked effectively to just be able to screen out issues, already get advance notice on projects of interest or things that might be impacting us. And so trying to establish a local regional relationship kind of on a periodic basis has been really helpful for some of our clients. And it gets to a point where then the relationships vary one-to-one, and you have federal officials picking up the phone and calling to the tribal office or calling our office, and we're all on the same page, which is half the battle here.
Thank you very much. And now I'm going to turn to a few more specific questions to some of your cases. The first one is for Pablo. I'm interested in learning how a license differs from an easement or a lease.
Yes, so generally speaking, a license is less than the needed permission given for like an easement or a right of way. There's sort of like a ladder. The way I was taught in law school is ownership is a bundle of sticks, and giving a person a license is just having one of those sticks, as opposed to getting something more formal like a right of way, an easement, a lease. Those require more. And so in the situation that I gave, and I know I went fast in my story, the city of Santa Fe, that's really all they needed. They needed permission to get on the trust land in order to maintain this hydrant. But what they've been used to with all the other adjacent landowners was getting an actual lease. And so once we were able to talk about what they really wanted, we were able to move from something formal, which would have required, I don't know, like I said, a consent of 19 different tribes, and then going through the Bureau of Indian Affairs, doing the appraisal, all of those things that the regs require. The city was satisfied with just literally permission from the school in writing to come to the trust land in order to maintain that. So that wasn't, I answered one of the questions on the chat, but that did not require BIA approval. That doesn't work in all situations. You can't get away with just saying, well, let's just call it a license and move forward. But in this situation, I don't like to use the term thinking outside the box, but I like to use the term thinking around the box. And that is what's really on the other side of this stumbling block or this dispute here. And if you can see around it and a way out, that's usually a really good advice to give a client.
Yeah, I think that's a really positive way just to see the stories that we're talking about here today is, less as something that's holding us up and more about something about how to get around that, and I mean, in legal ways and in ways that support our nations, of course, but I think it's important to have a positive frame of mind when we're dealing with these issues, even though it's really difficult to maintain that sometimes. For instance, with Justin, I'm not sure, how, you spent 8 years on this project, and that's a long time on anything like that. And you must have maintained a positive attitude the entire time.
No.
No way. That would be difficult. We do have actually a couple questions for you, Justin, that have come in, and because the story was really interesting. Does the tribe have jurisdiction over individual trust land, first of all?
So depending on, it sort of depends. It's a little bit of a gray area in terms of how the allotments came to be and what level the tribe has exercised jurisdiction over those allotments. So the example I gave, these were historic reservation lands that had been historically allotted. the tribe had in the past exercised some form of jurisdiction over those allotments, but everything became so fractionated, and I don't believe many of them were occupied to the point where it ever was an issue. And the tribe took the position in developing that civil trespass code, essentially that we're going to create two processes by which the tribe can exercise jurisdiction over tribal lands. You're creating a tribal land process and an allotment land process. The tribe doesn't initiate the process to investigate or take enforcement action on allotted lands. The allottees request that. So somebody would come in and say, hey, somebody dumped trash on my allotment, or illegally poached game on my allotment. And that would trigger a process by which the allottee would ask the tribe to investigate it, and the tribe would then assert jurisdiction, assuming its investigation led to a trespass. But I've looked at this for years, and I'm sure maybe people disagree, but it seems to be a bit of a gray area, because a lot of times the historical reason for the allotment doesn't really support that it was part of the tribe's reservation lands. But we would always take the position, as a tribe, to encourage that exercise of jurisdiction because it benefits a allottee in this kind of circumstance. We decided not to just say we're not going to deal with allotted lands, and then at that point the allottees would have no really recourse. They would have to start over again and have to come up with a process entirely of their own, or rely on federal regulations or federal intervention.
And how does the tribe determine valuation for tribal lands?
Yeah, so what the Code of Federal Regulations and federal law require really is that a tribe cannot agree or consent or authorize a right-of-way or easement, an encumbrance that is less than fair market value. And so fair market value, and I really appreciate this question, fair market value is a floor, right? It's a floor based on non-comparable land transactions. So, and this is again where this is kind of interesting in the story of allottees, but tribal lands cannot be condemned through eminent domain or inverse condemnation by utilities. They're in trust. It would need essentially an act of Congress for a utility to say, we're going to pay you fair market value. We now own that. You see that on fee lands all the time. In certain circumstances, a utility will have the ability to condemn allotted lands that are not restricted in any way. And so the default position that you're going to be dealing with regard to utility companies is they're going to be in a practice of determining the lowest fair market value. And they're going to think that that's their starting point in these negotiations. That is not, you cannot compare fee land next to the reservation and the value that that has on the fair market with tribal lands. Tribal lands cannot be condemned by a utility. So the value of those lands is really the value that Indian tribes have set for their lands. And so in my case, and in any other situation I would be dealing with, I would hire an economic consultant. In this case, I hired the Center for Applied Research, and we had worked with them on multiple projects. Chad Lindsay is who led that project for me. And they look at comparable rights of way in Indian country across the nation to determine what the settlement value or the ultimate value that the parties agreed upon, based on the type of line. So you may have a small distribution line or a large transmission lines, which are going to have different footprints. They're going to encumber more or less tribal lands. So you hire somebody, or maybe the tribe has an ordinance that establishes a per acre value. At some point, the tribe is going to have to set a value. And we looked at comparable Indian land transactions, comparable right-of-way negotiations, and applied that as a formula to that opening offer that we had. But again, to repeat, this is the only guidance you have is a fair market value floor. So it's really up to you to understand that if you rely on other people to dictate the process, more than likely you're going to end up on that floor, and that's not a good result for tribes, because now their lands are no more valuable than fee lands off reservation, which fundamentally is not the case. It should never be the case. For allotee lands, because there are instances in which the utility company can actually come in and exercise eminent domain and essentially own the trespass or the right of way. That they now own that as their property, as they've done historically on fee lands. The value might be a little bit different, and so you may be dealing with either making a decision as a tribe if you're leading these negotiations on behalf of the tribe and hopefully leading them for allottees. You maybe make the decision to differentiate the value based on the fact that you're dealing with trust lands that can't be condemned and allotted lands that may be condemned. And so maybe you split, or maybe you assign a different, or maybe to make things a lot easier to get allottee consent, and so there's more equity, is you have the same valuation for trust lands and allotted lands, which may lower the amount of value for trust lands than you would have originally thought. It may heighten the value of allotments, but when it comes down to putting a legal document in front of an allottee that you've never met, sometimes that's an incentive to show what the tribe has sort of developed as its proposal to encourage them to sign the consent that you need to close the whole deal. So, so valuation really is a matter of actual Indian land comps, not relying on the neighbor fee property and what they got on the sale of their property or the right of way that they have.
Well, thank you for explaining that a little bit better for us. Is it possible, I know that, in the case that you were referring to, perhaps, you can't say the tribe, but we do have some land professionals who are interested in looking at the ordinances that you're referring to. Is it possible to get a copy of the ordinances that maybe can serve as a framework for other tribes looking to create their own?
Yeah, and unfortunately, I should have done that before. I've been intentionally vague on everything.
Sure.
Because I don't have their permission to share specific either legal strategies or anything like that. However, I will ask and I will follow up, but hopefully with the understanding that if we share something, maybe I can send it to you or the foundation, and then it can be disseminated. But I will ask and I will do my best to get that.
This is Pablo. My recommendation for everyone would go to the National Indian Law Library. That's a subset of NARF. There you can find lots of really good ordinances, including trespass ordinances. Also, many tribes now publish their ordinances on the internet. And so I don't have any one specifically to go to, but if you do a query, you should find some. I'm not of the opinion that you should take an ordinance from another tribe and just boilerplate put it on your Indian tribe. But at the same time, there's a lot of really good resources out there. There's also this, well, I'll stop there. Those are resources that you all can utilize in order to see what other Indian tribes are doing with regard to trespass.
Yeah, that's certainly something here at the foundation. We have land professionals and attorneys and other leaders who are looking for just examples of how something works, because it can be difficult, when we're starting, from scratch or with limited expertise with our nations, to do something. So whatever sharing that we can do, we'll definitely do that. And thank you for the resource, Pablo. That's really helpful to be reminded of. Actually, I had forgot about that. That's a good resource for some of that information. So thank you for that. We only have a few more minutes, but I want to get through a couple more questions and then we'll end. This is in reference to Justin's piece again. Does the lease revenue have to be held in a BIA trust account? That's what the BIA rights of way guide states.
So a lot of that guidance, I think, is a little outdated, and it may depend on your discussions with BIA, but the checks that the tribe received essentially came directly in for the right of way and for the trespass penalties. Those came directly from the utility to the tribe, and the tribe had to essentially submit proof or acceptance of payment to BIA to ensure that those had been processed. payments to allottees do have to go through that, the TAM system for distribution to the allottees, which is great because it's now their sort of administrative burden to make sure that the payments are accurately parsed out to the allottees.
Great, thank you. So we have a few more questions here. I'm going to see if I could read these correctly. This first one here, do tribal members who own land allotments, does it create a trespass to tribal lands or other violation of tribal rights, have a duty of care to their tribe? I may be missing some words in there.
It's probably a little bit related to my situation. So I have not ever encountered that issue. I mean, obviously, when you're dealing with trespasses or harms that can occur to tribal lands, potentially a trespass code would apply. There's really no difference between a member or a non-member, but more often than not, you're dealing with non-members. And these codes would cover everything from, someone illegally entering tribal property to do something, to dump tires or something like that, all the way up to, big transmission lines. And so you would create a system, and the tribe, I think, would have jurisdiction over members, or even whether they're allottees or not, if they are harming the tribe or they are triggering action under the ordinance. So if they are themselves harming allotted lands, I don't know how that would work. I guess that would be up to them, or they're harming a neighboring allottee. I think the code that we utilized created room for that, created an enforcement mechanism by which an allottee could seek redress in the form of getting the tribe to investigate and intervene on that trespass.
Thanks, Justin. And I think we're going to have one more question here, and then I'll close out our session for today. Can the tribe legislate for mandatory arbitration of disputes within the tribe, third parties, and state and federal government? Is mandatory arbitration available to tribes for disputes with BIA or other government agencies?
Want me to take a crack at that one?
Sure. So let me see if I can find that. I thought I saw that one. Can the tribe legislate mandatory? Okay. Well, in the context of third parties, I'm gonna separate BIA and governmental agencies for that, because the way those are resolved are all under federal law, all under the stuff that I think the four of us studied in our maybe third year or second year of law school. But those are separate mechanisms prescribed by statutes in which a tribe may has to follow a certain process to seek redress from the federal government with regard to disputes that it may have. And separately, depending on what the dispute involves, there may be some sort of an agreement already in place between the tribe and a federal agency or a state agency that has its own dispute resolution process. So the tribe can't really legislate what the federal government needs to do regarding disputes with the tribe. But for third parties, so private individuals, companies, the tribe can certainly, in its codes, describe the process in which it can take action against those individuals, or those, and limit what those individuals may do to take action. And it can include options, like tribal court. It can include options like arbitration or mediation. It can describe the process. Obviously, you're going to be dealing with third parties or companies that just do not want to follow that process and immediately seek some sort of a redress in federal court or ignore entirely. And so it's really up to the tribe to be aggressive about pursuing its own jurisdiction when people enter tribal lands, harm tribal lands, or are contracting parties with tribes, to make sure that those processes are either codified or included in the contracts that may create the relationships with those third parties.
And I think one of the things that's important in doing so and developing that infrastructure, that legal infrastructure that provides that, whether if it's tort or contract, it gives leverage for the tribe when they're negotiating if those disputes can be heard through a tribal forum, whether if it's through court, arbitration, or mediation. So to have that in place is helpful for tribes as they negotiate with third parties. And so having that set up is going to be something that, because you're constantly having to resolve these dispute resolution clauses in contracts where they're requesting the tribe to resolve disputes in state court or another forum away from the tribe. So it gives a little bit more leverage in negotiating contracts if the tribe has something in place that limits, one, the liabilities of the tribe, but also puts the forum back on a tribal forum. Thank you.
Thank you both. I think, this has been a really great conversation. We do have a few more questions in chat, but we're at time now, and we're all busy professionals, so I'm going to have to release everyone for this. But I do want to extend, my deepest gratitude to Pablo, Casey, Aaron, and Justin for their participation and sharing today. This has been a really meaningful conversation that's illustrated a lot of challenges, but also ways to work through some of those pieces. Certainly in the coming days, everyone who registered for this webinar will receive a link to its recording posted on the Foundation's Vimeo account, and along with an evaluation link. Now, the questions in that link are important to answer, but some of the pieces that I'm the most interested in, it'd also be some of the topic areas that you'd like to see covered in future webinars, even if they include negotiations of different pieces specifically. One of the pieces that I've heard for the last several years from our professionals and land offices across this country have been that we need more information about negotiation. A lot of our professionals or staff are coming in brand new to these positions, and they need that experience. And so, we're certainly here. The Indian Land Tenure Foundation and the National Tribal Land Association, we're here to help to provide these resources to you all. And certainly today, I'll say that, we had a dynamite team providing these recommendations. So again, my deepest gratitude to all of you and to the participants in today's webinar. Stay tuned for more programming going forward, and I look forward to seeing you all again soon.
Have a great day, everyone.
Thank you, everyone. Thank you, Nick.
everyone.
Thank you.